Welcome, everyone. Thank you for joining us for the second session in our series on remote work. Today, we will be covering the Americas. I am Hannah Shea, World Law Group's Manager of Communications and Network Development. And I just wanted to cover a few housekeeping items before I hand it over to our panel. You have been muted upon arrival, and we ask that you remain so throughout. We're trying to keep the session to 30 minutes, and it will be recorded and available on our website next week. If you have any questions, feel free to drop those into our chat feature. We will be monitoring that. If we don't get to your question during the session today, we will reach out to you via email. I'm now going to hand this over to the Americas co-chair of WLG's Human Resources Law Group, David Wolf. David?
Great. Thanks so much, Hannah, and thanks everyone for joining us. Good morning, and to anyone watching from Europe or Asia, good evening. Or good afternoon. I think we have a great panel today. This is the second one. We've done Asia last week, and the Americas I think will be just as interesting. Our panel today is really a great group. We've got Brian Swagman from Goodmans in Canada, Santiago Madalena from Uruguay, and Gabriela Lima from Brazil. And so let's kick it off with, I guess, the first question to Santiago. What do you think? I mean, one of the hot topics that's come up since COVID is this idea of digital nomads or nomad visas. Is that something that you're seeing in Uruguay? And if so, how does it work?
Thank you, David, for the question, and hi, everyone. Yes, you know, in Uruguay, we have a very recently approved legislation on remote work. It was approved last year. It doesn't mention anything regarding digital nomads. But at the same time, we get used to have people coming from abroad to working in Uruguay as nomads. And it was a problem because in principle, applying the general regulations, you know, if you come here to work even for 1 week or 1 month or whatever, you should be registered here. You should pay social security contributions in Uruguay, and your employer should be registered here. And it was a problem for those companies sending people here. But a couple of months ago, an immigration regulation was approved, and it states that those foreigners who come to work here for no more than 1 year can request a very simple work permit. It is only necessary to file the request and to prove that you are working for a company located abroad, maybe with an employment contract, for example. And the regulation expressly states that you shouldn't be registered before social security contributions. So this is good news for the problem that I was mentioning before. The regulation has some limitations. For example, it obviously doesn't apply for Uruguayans who work for companies located abroad, which is a very usual thing here mainly in the software industry. You know that we have plenty of developers, programmers working for the US, for Europe, but the regulation is only applicable for foreigners. And also, it doesn't cover the situation of the tax on income. You know, the employee here has to pay the tax on income. The only exclusion is for social security contributions. And the other thing that is something different from labor law, but that it is necessary to point out, is the possible risk of a permanent establishment of the foreigner company here, you know, because it will depend on the number of employees here, on the kind of tasks that these persons are doing, and on the period of time that they are here. But eventually, the foreigner company may be considered to have a permanent establishment here, and this has a tax impact because the tax on income of the business income of the company, eventually a part of that should be paid here. So it's something away from employment law, but that should be considered in these kind of situations.
How about in Brazil, Gabriela? What are you seeing there?
So here in Brazil, we got a kind of similar situation to Uruguay. We got this question a lot during the pandemic, and for a while we did not have a straightforward response. We had the response with risk. But since January of this year, our immigration authorities issue a new regulation, what we call Normative Resolution number 45. And this regulation clarified some points for us. So first, the regulation clarified that a foreigner with a visitor visa may come to Brazil and work remotely for his company abroad during the length of the visitor visa. So this was a plus because we had this doubt if a visitor could still work remotely without risk. So now, yes, it's perfectly fine. And then the resolution said, if the person wants to stay in Brazil more than the length of the visitor visa, the regulation establishes the rules to obtain a digital nomad work visa. So in order to be able to apply for this digital nomad work visa, the foreigner needs to have like a declaration and statement that he or she is able to work remotely using telecommunication devices, that this person has a relationship with a contracting company abroad, maybe an employment relationship, maybe an independent contractor relationship, just need to evidence that has a contract with this hiring company abroad, and also has to evidence that due to this relationship, the person receives at least a monthly amount of the equivalent to $1,500 US, or if this person doesn't have this payment monthly, has a bank funds available in the equivalent amount to $18,000 US. And this person also has to show that has a health insurance valid in Brazil for the period the person wants to stay in Brazil. The digital nomad work visa is initially valid for 1 year and may be extendable for an additional 1 year. So the person may have the digital nomad status for up to 2 years in Brazil. And with the digital nomad visa, the person will not be subject to Brazilian employment law, will not be subject to Brazilian social security law. So this is also very good information. But the person will become a Brazilian tax resident. So whenever you are sending someone to Brazil to be a digital nomad, it's always recommendable to let this person knows that he will become a Brazilian tax resident. It's recommendable to verify if there is a treaty to avoid double taxation. And the last thing I'm going to say at this point is that the person also is not allowed to work with the local market to avoid what Santiago also mentioned related to the permanent establishment of the company. So if the person continues to work to the company abroad, that's fine. If the person wants to have interaction with the local market, this may represent a tax issue to the hiring company.
Great. How about, Brian, you and I are not in the warm weather climates that maybe Santiago and Gabriela are. Are you seeing the use of digital nomads in Canada?
Yeah, thanks, David. I guess before I get into it, I just wanted to thank everyone for attending, and thanks for the invitation. But to your point, David, the climate in Canada scares away some of the digital nomads, so we haven't seen it as frequently, and there aren't any programs specific like Brazil or Uruguay, and there hasn't been specific legislation. If someone does decide to brave the cold and come here to work, they work under the traditional work permit or as an independent foreign contractor under a temporary resident visa. These are the typical immigration programs that have been in place in Canada, and there's nothing special for COVID or the rise in digital nomad. What we're seeing more often is people leaving Canada and working abroad other around the world. And so there's more Canadian employees. Oh, my lights just went off. I apologize. Digital employees or Canadian employees working abroad. And for those, we've been recommending employers to enter into a remote working agreement and making sure that there is some oversight to the working abroad. A remote work agreement lays out some pretty standard terms, like the company approval to travel, lays out a home office, business hours, so that there is some consistency with the company intentions and the ability to travel. and the ability for the employee to work wherever in the world and to be a digital nomad. And then similar to the issues that Gabriela was raising, there's tax issues based on residency and based on time in a country, in Canada, if you're coming into Canada, or outside of Canada. So there's always the consideration of making sure there's a tax treaty in place, or that there's appropriate withholding taxes for the appropriate jurisdiction that they're in. The other consideration I was going to mention is the application of Employment Standards Acts. And so if there's a digital nomad coming to work in Canada, and someone is living here but working remotely, the employment standards of the applicable province or jurisdiction will apply to that person. So a company should make sure that they're remaining compliant with whatever the local and applicable employment standards are.
Yeah, thanks, Brian. That sounds a lot like the United States. I mean, I'm sure there are some people who come here kind of in a digital nomad way, but we don't, like Canada. In the U.S., there's no digital nomad visa status or immigration status. Someone who wants to be here would have to apply for a kind of a traditional visa and come in that way, and wouldn't have a separate status as a nomad. We too, at least my practice, and I think most people's practices here, are seeing more questions of what happens to U.S. employers or employees of U.S. employers who want to go abroad and take their laptop with them and work from abroad. And it's a very similar analysis to what Brian described in terms of when you go to a country, how long can you be there without triggering certain immigration issues, certain tax issues, and dealing with those. One kind of U.S. wrinkle beyond immigration, I would say, is we don't have like the ESA, like Brian was talking about, in terms of in a lot of countries, especially in Europe, in terms of if you want to sever an employee or terminate their employment, there's no, we have what we call at-will employment, but we do have very strong anti-discrimination laws and wage and hour laws, and the courts have said that those apply to foreigners who are working in the United States. So that's just something to keep in mind. Gabriela, how about you? I mean, you mentioned kind of people coming to Brazil. Are you dealing with situations in which Brazilians are going abroad and having to deal with the types of issues Brian was talking about?
Yes, sure. Thank you, David. Like we do also have Brazilians wanting to go abroad. And for this situation, our Brazilian employment law also has a new good thing, is that now we have a clarification that if you want to go voluntarily abroad, it's not considered a transfer. So like this does not, it is allowed and does not create additional burden to the employer. And what we recommend to our clients is that because everyone is now interested in anywhere office, right? Every employee wants to go a little bit abroad and be able to work remotely. So it is, in fact, an attraction and retention tool. Our clients are implementing policies. And when we help them to do that, what we recommend is to make it voluntarily. If you want, then the person applies to the program. Make sure that you check the law of the place where the person wants to go to work to see if there is any requirement for digital nomad visa or any other type of work visa. To also check tax regulations because of the tax residency thing and double taxations rules. We strongly advise the company here in Brazil to recommend the employee to have an international health insurance, because the person will continue to be linked to the Brazilian company. So we will continue to be linked to all of our health and safety rules. And we do have very strong health and safety rules related to remote working. And even when remote working, you may have a work-related accident. And if you are abroad, it's huge recommendable to have a health insurance that is valid in the country that you are. And one thing is that we do have here in Brazil a regulation related to remote working. So you do have to implement a health and safety written policy to explain to the person how the person needs to take care of himself or herself while working abroad. So those are the main points. We also recommend to have an amendment to the employment agreement to make sure confidentiality will be also taken care of. But those are the main points, and all of our Brazilian employees, they are very interested in going abroad too.
And one thing I see, Gabriela, when we have people going abroad is I'm always interested in, you mentioned the permanent establishment issue. Santiago mentioned it as well. Are you concerned about it when someone goes abroad too? And is it worth checking with the host country? For example, if they go to the UK, would you typically check with the UK and make sure you don't have that Brazilian company with a permanent establishment issue in the UK?
Yes, for sure. Like that's why we like, because we are from Brazil, we are only allowed to work with Brazilian law. So we also work with all of our friends law firms in order to be able to obtain the proper recommendation, because we need to pay attention to companies' taxes, companies' regulation, and also the employees' taxes. So like it's very important to check if there is any permanent establishment issue in the country the person will go to.
Great, thank you. How about you, Santiago? Are you seeing folks going abroad from Uruguay too?
Yes. Also, we are seeing this. We are seeing this as a benefit that companies are starting to give to their employees. The same recommendations that Gabriela mentioned before are applicable for Uruguay. I mean, it's recommendable to ask the person to hire health insurance. It is very strongly recommendable to check everything with relates to the legal status of the person abroad, the migration status, the tax status, to make it voluntary, to have, if possible, a written agreement. And the other thing is that we are also seeing people working permanently for abroad in some cases, which is something that our employment law allows. You know, it is not only valid to have someone going abroad for a couple of months just as a benefit given by him or her employer, but also to have people permanently working abroad. Sometimes it is something recommendable because of the possibility of being paid in Uruguay with a foreign currency. Sometimes is because of people who have some seniority and prefer to work in another country, and this is valid. The only limitation that we have here is that in case of free trade zone companies, in that case, you need to have the people working in Uruguayan territory, but for the rest of the companies, employees can work from abroad. And that is perfectly valid according to our law. You have a problem that you may have is to define which is the labor legislation applicable to that employee, you know, because one thing is if you send someone to go for a couple of months abroad and then come back, but another thing is to have someone permanently working from Brazil or from Argentina, for example. In that cases, maybe you can have a problem defining which is the applicable legislation. But apart from that, and apart from the tax risks that we were mentioning before, this is a perfectly valid situation from a Uruguayan legal standpoint.
Great, thank you. One of the things I'd love to ask you guys about, you know, that I see in the U.S. or questions that I get is, especially around immigration, it's a little bit of a mixing of an issue. You know, immigration is its own issue, but related to that is kind of employee and independent contractor status. And I get calls from clients from time to time who say something along the lines of, well, I'm going to make the person an independent contractor, so it's okay, right? Like, for example, we had one several weeks ago where they didn't have an office in Canada or established business in Canada or a Canadian subsidiary, but they said, well, we want to use this person in Canada as an independent contractor. We assume that's okay because they wouldn't be an employee. Does the contractor status, and we'll throw this to you, Brian, first, does the status in the US, you can get a visa as a contractor, but there's not as many opportunities for it. Most of the visas, or many of the visas, are designed for people who are going to actually be employed in the United States as opposed to a contractor. In Canada, does the fact that someone wants to come in as a contractor versus an employee, or they're going abroad as an employee or a contractor, does that change the analysis at all?
Yeah, it doesn't have as much of a change on the analysis, especially if they're working for one employer. I mean, it's similar to the US, there's the classification issue that you would have if they're a dependent contractor or an employee, but only working for one employer and using that employer's materials and doing all the work from there. But if there's an independent contractor, there is a different visa application. So if you're an employee working for a Canadian employer, you could apply for a specific work permit and the work visa to permit you to work for that single employer as an employee. Whereas if you're coming in as an independent contractor, you could work under the temporary resident visa. And as I mentioned before, if you're working for an independent or a foreign company and you're not working for a Canadian company, then you would work as an independent foreign contractor. And it would be a different visa application. So it's a similar analysis to if you're working for a Canadian company or a foreign company. But it impacts whether the person is considered an employee and applying for a specific, it's called the LMIA work permit, or working under just the resident visa.
Santiago, how about you? Does it matter if the person if they're coming into Uruguay? Does it matter if they're coming in as a contractor or an employee?
No, I mean, the migration, the regulation is applicable for both of the cases. Maybe what we are most used to see is people coming as employees for foreign companies. And on the other hand, people from Uruguayans working for abroad, the most usual thing is to see them working as independent contractors, you know. So in that case, you don't have the migration problem because someone from Uruguay that has a written services agreement with a company abroad, generally with clauses stating that the applicable legislation is the one of the company from abroad receiving the services. And as we are all aware of, these situations always trigger the tax and the labor risks of the reclassification of the situation. Luckily, in Uruguay, the courts are strict with the claims in terms of the independent contractor is the one who has the burden of the proof, you know, and who has to prove that he or she was an employee and not a contractor. But anyway, it's a risk that you always have. And the other thing is that this is very usual in the software sector in Uruguay to have contractors working for abroad, but it's not usual at all to have claims. You know, it's a sector where you have zero unemployment, where people are very happy with their services and they have good salaries, and they resign to one company and they get work immediately in another one. So it is something that a risk that theoretically exists, but in the facts is not usual at all to have this kind of claims against companies abroad, you know.
Okay. Gabriela, how about you? Are you seeing mostly independent contractors or employees coming from abroad into Brazil?
So like for the digital nomad work visa, it doesn't matter. You can be either an employee or an independent contractor. You just have to evidence that you have a relationship with the company abroad. So that is not an issue. The issue is pretty much similar to what Santiago just mentioned. Like what we see a lot is foreign companies trying to hire a lot of Brazilians because they don't have enough workers in their countries, or because hiring Brazilians are cheaper than hiring nationals of their countries. And in order to hire someone in Brazil as an employee, you need to have a Brazilian branch, a Brazilian subsidiary. So because the foreign companies do not have, they hire the Brazilian workers as independent contractors. And then there is this risk of reclassification to become an employee. So what we always tell our clients, international clients, is that Yes, if you hired someone as independent contractor, even though the service agreement will be stating that the person is an independent contractor and the law that will be applicable is the international law. Here in Brazil, this person is allowed to file a labor claim to try to become recognized as an employee. But although there is this risk, it's very uncommon, like Santiago said, to have an independent contractor filing a labor claim against a company abroad. It's time consuming, it's expensive, and most of the time they are happy with the situation because they are receiving their remuneration in foreign currency. They are receiving a better package, but the risk exists mainly because here in Brazil, we do have very protective law for employees. So we have protection upon termination, we have mandatory severance, and when the relationship ends, sometimes the person is not very happy with the package her received and may come up to a labor claim.
And thank you. Real quick, because I know we're running out of time. One thing I hear is, choice of law. So for example, someone comes into the US and they're a UK national and they say they want UK law to apply, and then the person files a claim potentially under US law and they want to stop that. And realistically in the US, if they're working in the US, they're going to be subject to US labor law. Brian, if I go to Canada and I've got an agreement that says I'm subject to US law, does that mean I'm free from kind of Canadian regulations, or am I stuck with those two?
Yeah, same thing, and similar to the US, that the laws of the jurisdiction, if the employee is working or independent contractor is working in that jurisdiction, they'll apply, and they can't contract out of that.
Same thing in Uruguay, Santiago?
Yes, in Uruguay, we have a very recent law stating that the parties to the employment contract can choose the applicable law. So this was very new for employment law scholars. So we don't know how this is going to be taken tomorrow in case of a claim, for example, but we have the regulation. What you should check is if you have an international treaty with the other country, because for example, with Argentina, that we have a lot of people coming from Argentina to work in Uruguay, that possibility is not an option, Nevertheless, with other countries that are not part of treaties with Uruguay, we can apply the law, and the option of the law is valid.
Well, that's okay. Great. And Gabrielle, we'll give you the last word on that. It sounds like in Brazil, you can't contract out of Brazilian law. Is that right?
Yes, no, we are similar to Canada and US. So even though you may choose a different law, the Brazilian law will apply in the event of a dispute.
Okay. Good. Well, I know we're at about a half an hour, and so I really appreciate everyone's contributions and participating, and thanks to the audience too.
Thank you. And as David said, unfortunately, our time is up, but I'd like to thank David, Gabriela, Brian, and Santiago all for your insights today on remote work. If you do have any questions that we didn't answer today, whether it's a general question or specific to a jurisdiction, please feel free to send me an email at hshay@theworldlawgroup.com, and I'll get those answered for you. The recording for this will be available on our website next week. And we also invite you to join us for the next session in the series covering EMEA on Tuesday, October 11th. So thank you again, everyone.